Good morning, everybody. We're gonna go ahead and get started here. We have a busy day, but I wanted to make sure that this is the last day for Senate files to come across, and so wanted to make sure that every senator had the opportunity to get their voice heard. So with that, let's go ahead and call the roll.
Here.
Representative Brett.
Here.
Representative Chester.
Here.
Representative Filer.
Here.
Representative Kelly.
Here.
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 Representative Webb.
Here. Here.
Excellent. So the first bill for our consideration today is Senate File 122. Senator Cooper, can you introduce yourself for the record and go ahead and explain Senate File 122?
Thank you, Mr. Chairman. Ed Cooper, Senate District 20. This is Senate File 122. This is a bill that came up a couple years ago, folks, that a lot of you aren't familiar with it. A few of you are. But this originated from an incident up in the northern part of the state where a person put a camera in a ladies' restroom, change room, and recorded some 10,000 plus images of the ladies that were working with him as they were in a place where they expected privacy and deserved privacy. When we passed the bill's pretty simple itself. On page 1, line 15, it strikes the word "if the victim was a minor." That's the entire change to the bill. And keep in mind that this is for the victim, not the perpetrator. If the victim was a minor, the bill is in place as it is, but it removes that requirement for it to be just a minor. And so it would be for any victim, if you would, of a felony voyeurism. And the important thing to remember here is that this is only if it rises to the level of a felony voyeurism. About 20% of the people that commit this crime, when they get out, they're repeat offenders, and they're not currently required to register as a sex offender. So again, we're trying to just expand that from minors only to any victim. And it doesn't, there's been questions, well, if it's a boy, 18-year-old taking a picture of his girlfriend, no, that's not a felony for one thing. And it doesn't matter how old the perpetrator is. That's not part of this. So with that said, I'd like to bring the victim online if that's suitable for you folks, and let her tell you her story. And it's a pretty compelling story. So
Thank you, Senator Cooper.
for reasons of, Mr. Chairman, excuse me, for reasons of privacy, it'll be her first name only, and she will not have a video for us. Mr. Chairman, thank you.
Melanie, if you can hear us, go ahead.
Yes, I'm here. Can everyone hear me okay?
Thank you. Please proceed.
All right. First of all, I would like to thank everyone for allowing me the opportunity to speak today. I'm here today in favor of the bill that would make those convicted of felony voyeurism required to register as a sex offender, regardless of whether or not the victim, or in my case, victims, are or were minors. I have been directly impacted by voyeurism. Back in 2019, when I worked at a previous place of employment, I had frequently used my lunch breaks to enjoy walks outside. I also used the workplace bathroom to change my clothes before and after my lunch break. One day I had returned from a walk and changed my clothes like I had many times before. And while halfway disrobed, I spotted a web camera sized recording device located under the sink in the bathroom. It was pointed right at me. And that began the nightmare that has brought me here today. Police uncovered over a year's worth of video recordings, which they equated to over 100,000 captured images. A male coworker had been placing a camera in the women's restroom for years. I ended up having to go down to the police station to identify 3 of my fellow female coworkers using the restroom. and they in turn had to identify me doing the same. To say that this was just an invasion of privacy is a huge understatement. Part of the evidence showed the perpetrator taking mock video and images of himself sitting on the toilet so he could capture the preferred angles and recordings that he wanted to capture. This was not an accidental crime. This was premeditated and it was malicious. When a person uses a bathroom or even a fitting room, they assume they are alone and in a private space. Think of the times that you are in a restroom and you're using the toilet or changing your clothes, especially in a workplace environment or in a public restroom. A level of privacy is expected that we all take for granted. He violated that privacy to the billionth degree, in my opinion. The perpetrator in this case ended up being convicted of 4 felony counts of voyeurism, 1 count for each victim. At the time of his conviction under the current Wyoming law at that time, the punishments for this crime were very minimal with regard to prison time. They had been written before technology existed and certainly didn't cover the plethora of ways that a person can now commit this crime by using recording devices such as video cameras, web cameras, cell phones, etc. Therefore, I feel as though he got a slap on the wrist for his punishments, and he also was not required to register as a sex offender. No matter the age of the victims involved, voyeurism needs to be seen as a crime of a sexual nature, and those that are convicted of felony voyeurism need to be required to register as a sex offender. It is exploitation. This person had been watching me use the toilet for years, as well as 3 of my fellow coworkers, and had been watching me change my clothes after exercising. He knew my routine and my schedule and used those opportunities to violate me. The person who committed this crime against me ended up serving 2 years in prison, and upon release was required to also serve 2 years of supervised probation. Once he was out of prison and on probation, I was never informed of his whereabouts. I was never informed of his workplace or his current address. If he had been required to register as a sex offender, not only would I have been made aware of his whereabouts for my own safety, but it also would have been for the safety of the community as well. In fact, I heard nothing about him until after he had violated probation and was needing to appear before the judge for sentencing. He not only violated his probation in one way, but in 3 different ways. He did not complete the required sex offender classes. He was also found in possession of pornography, and he was in possession of an internet-capable device. His violation of his probationary time is just further proof that he is in fact a predator and highly likely to reoffend. He was and is a threat to the community. Unfortunately, he was not required to register as a sex offender because that wasn't part of the law that was in place at the time of his conviction. However, I'm hoping today will be the start to a positive change to the voyeurism laws here in Wyoming. Victims of voyeurism deserve more protection and the right to feel safe. This crime can affect anyone at any time. This violation of privacy is not specific to only minors or only women and needs to be viewed as a sexual crime. If a person is attempting to view another person in a space where they are at their most vulnerable, they should be seen as a predator and be registered as such. A person doesn't view another person in a private space like a bathroom without the intent of capturing them in their most vulnerable state, which is without their clothes on. I was targeted. He was waiting for me to leave the restroom so he could grab the camera and view its contents. He wasn't banking on getting caught. What kind of person wants to watch their coworkers use the restroom? His actions were not an accident. They did not happen by coincidence or mistake. They were intentional and they were sexual in nature. He is a predator, and predators will continue to hunt until they found their next prey, and they don't stop after just one opportunity. This crime is happening way more than we realize, and with the amount of technology available and the amount of pornographic materials at everyone's disposal on the internet, this type of crime needs to carry harsher punishments. I appreciate your time today. I kindly do request that we work together to ensure safety and protection for victims of this felony crime and for our communities as a whole. Thank you so much.
Thank you, Melanie, for that testimony. Do you have any questions from the committee? Thank you for sharing what you've shared today. That is a traumatic experience. And so we need to make sure that the conversation that we have about what happened is just and fair. So thank you for sharing that.
Yes, thank you so much to everyone who's listened today. I do appreciate it.
Senator?
Chairman Singh, committee, I find this crime to be, especially to this level, to be just absolutely repulsive. And to think that we would limit this to just the victim being just a minor is really an injustice, in my opinion. I believe that our 19-year-old daughters and granddaughters deserve the same protection as our 17-year-old daughters and granddaughters. And Ms. Chambers is here to answer any questions you may have as far as the legalities of it or the technicalities of it. But I'd sure appreciate your consideration on this bill. Thank you.
Chairman Watchett.
Thank you, Vice Chairman. Ms. Chambers, can you remind us what differentiates misdemeanor from felony voyeurism?
Ms. Chambers.
Thank you, Vice Chairman Singh and Chairman Washut. The difference has to do with the age and it's how the voyeurism is captured. So if it's more of a peeping Tom situation, it would be a misdemeanor. If it's as described by our victim today, that is the felony. There's also, under the voyeurism statutes, just so we're clear that we're not also making young children felons, there's a caveat if the minor is the offender, and then it's a misdemeanor. But then there's also an enhanced penalty if the offender is over the age of 18 and the victim is under the age of 18. But so that is mostly the level of how it was done, and the intent behind it is the difference between a misdemeanor and a felony.
Chairman Watchett.
Thank you. The victim mentioned greater punishment, but this bill's not about punishment. The sex offender registry is seen more as a preventive, is that correct, rather than as a punishment? Can you maybe elaborate a little bit on that?
Director Chambers.
Co-Chairman Singh, Chairman Washut, yes. This bill is merely adding the felony offense of voyeurism to the sex offender registry. We've had conversations about the sex offender registry and the various tiers. Yes, the intent behind having someone register is for prevention. There's a lot of data that suggests that sexual predators do not age out of their crime, hence long-term monitoring is recommended, and this would accomplish that.
Any other questions from the committee? Thank you.
Thank you.
Do we have any agencies that would want to speak on this? Any public comment? Anyone else online? Not an RJ Cost? Okay. All right. Well, with that, we'll close public comment. Committee, what's your pleasure? Moved by Representative Filer, seconded by Representative Webb. Is there any discussion on the bill? Any amendments? Question being called. Let's go ahead and call the roll on Senate File 122.
Representative Brady,
Aye.
Representative Breath,
Aye.
Representative Chestek,
Aye.
Representative Filer,
Aye.
Representative Kelly,
Aye.
Representative Lean,
Aye.
Vice Chair Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
9 ayes do pass.
Excellent. We'll go ahead and first, yeah, on the floor, we'll go ahead and communicate with the co-sponsor of the bill on the House side to present this bill, be Representative Connolly, unless anyone here would like to volunteer for this bill.
We can back her up.
We can back her up. Excellent. Thank you, folks. The next bill for our consideration is Senate File 101. Senator Landon, welcome.
Good morning, Mr. Vice Chairman. How are you?
I'm doing well. Good morning.
Mr. Chairman, Representative Chestek, remaining members of the last 2 years serving as a Senate chairman on this committee, and thank you for your work on that previous bill. The Judiciary Committee runs into some very tough issues. I'm Bill Landon, Senate District 27 out of Natrona County. Mr. Vice Chairman, and glad to bring you Senate File 101. Post-conviction DNA testing procedure amendments. Like many of our bills, this one came to me from a constituent up in my neck of the woods who works in our legal profession. And it took a case like this to shine some light on a hole in our statutes. This is all about federal legislation that was passed back in 2000 in an effort to kind of curb what was seen at that time by Congress as delays in court proceedings based on court-ordered DNA testing. That could be used at the time to delay proceedings, and it was frankly jamming up the courts with frivolous, what was seen as frivolous demands for this kind of testing. So there was some pretty stringent rules put in place by that federal legislation. Subsequent to that, the states followed suit. Wyoming was a little bit late to the party and did not pass legislation on this front related to DNA until 2008. That was a year of reform legislation by the Judiciary Committee. I think Senator Ross might have been the chairman at that time. I don't remember the House chairman. But a lot of work done, and along with it was a bill that addressed in statute 712-303 that federal legislation. So what the statute in Wyoming does is set a very high bar, just like that federal legislation. 303C under 712 says that convicted individuals must meet a rigorous standard to secure this court-ordered testing of previously untested DNA evidence. The standard is intentionally stringent and is consistent with similar statutes in other states and reflects a careful drafting of that 2008 legislation. Some of the momentum of that bill came from the Rocky Mountain Innocence Foundation, and it really is the impetus for why we go to page 2 of this bill. And Mr. Vice Chairman, the bill is very, very simple. What we do on page 2 is we simply move that date to 2008 to correspond with the date that Wyoming passed the law. To give you a little bit more focus on why this case is important and why it sheds some light, I do have our constituent streaming in this morning. Miss Emily Madden is online, and I know she can answer further questions you might have about the specific case. But in the meantime, I'd be happy to answer any questions regarding this little bill. So,
Thank you, Senator Landon. Any
Yeah.
questions from the committee?
amen.
Representative Webb?
Read over the bill, it talks about occurred after July 1st, and then down below, it's a person convicted before, or convicted before July 1st. Maybe a slim chance and a very slim probability, but if somebody was convicted on July 1st, is that gonna pose a problem?
Senator Landon?
Mr. Vice Chairman and Representative, that might be a very good catch. If you can find a way to make that language a little bit better or tighter, I would sure support that, so thank you. I would say, Mr. Vice Chairman, that quite honestly, we're not talking about probably a lot of cases. It took one in the last 20 years. And it's kind of interesting to think about it, Mr. Vice Chairman. Thank you, Representative, for the question that prompted me to go in this direction. But you think about an individual who might be proven innocent, for example, and is sitting in prison for life. what ramifications that might have of a fiscal nature, but more importantly, just doing the right thing. So we want to get the dates right for sure, but thank you, Mr. Vice Chairman.
Thank you, Senator. Any other questions from the committee? All right, so we have Emily Madden online. Let's go ahead and, excellent, let's go ahead and bring her up. Emily, can you hear us?
Yes, thank you, Mr. Chairman. Can you hear me?
Good morning, yes, we can. Please proceed.
Thank you, Mr. Vice Chairman, Mr. Chairman, members of the committee. My name is Emily Madden. I am a fourth generation Wyomingite, a UW College of Law grad, and I currently live in Casper where I practice law. I'm also a board member of the Wyoming Trial Lawyers Association. I approached Senator Landon about this bill after being appointed by Judge Johnson, one of Wyoming's federal judges, to represent Eddie Magallanes in his pursuit of post-conviction DNA testing. Eddie was convicted in 2006 of a crime that he did not commit. Eddie, there was DNA evidence that was collected from the scene that could and still can prove his innocence, but it was and it never has been tested. The very first time that Eddie learned that there was DNA evidence was during his criminal trial and after it was already well underway. Years later, in a related habeas proceeding, it was elicited via testimony that the public defender appointed to represent him rarely, if almost never, obtained independent forensic testing of DNA evidence because he wanted to preserve public funds for the benefit of employee salaries, including his own. Unfortunately, by the time that testimony was elicited, it was far too late for Eddie to use it for any purpose of challenging his conviction on direct appeal. Eddie's case bears several troubling hallmarks of a wrongful conviction, hallmarks that have been identified in empirical studies as leading factors contributing to wrongful convictions. And Eddie is exactly the type of person that Wyoming's Post-Conviction DNA Testing Act was designed to help. But unfortunately, he's been precluded from accessing the DNA evidence that he needs to prove his factual innocence because of the law as it's currently written. Under subsection D, which is widely known as a due diligence requirement, Eddie has been prohibited from accessing his DNA because of his conviction in 2006. But subsection D is designed to prevent instances where a defendant elects not to test DNA evidence because of the option to fall back on post-conviction DNA testing if they're convicted. So it protects against second bite of the apple defendants, and it incentivizes the diligent pursuit of DNA testing. But for those convicted before 2008, when the act was passed, it would have been impossible for them to make a decision based on a law that didn't yet exist. And for that reason, the 2000 cutoff creates unintended consequences, and Senate File 101 would simply seek to rectify that and change the date to July 1st, 2008, the day the act became law. This amendment is unlikely to result in a flood of petitions. Since the act's passage 16 years ago, Wyoming has seen only one exoneration under its provisions, and that was Mr. Andrew Johnson. He was convicted in 1989 and exonerated in 2013, but most notably, subsection D didn't apply to Mr. Johnson because of his pre-2000 conviction. The cost of this amendment is also an important consideration, of course, but DNA testing is relatively inexpensive, all things considered, especially when compared to the financial cost of imprisoning people for decades and the moral cost of incarcerating the innocent. In closing, this simple change would improve the statute's fairness, provide redress to individuals who meet the rigorous standard of subsection C, which Mr. Magallanes does, and it would also uphold the act's overarching purpose without overburdening the courts or public resources. If there are questions, of course, I'm happy to stand for them, but if there are not, I'd just like to thank Senator Landon and the bill's co-sponsors and the committee for their time this morning, and I would ask that you support Senate File 101. Thank you.
Thank you, Ms. Madden. We have a question from Chairman Watchett.
Thank you, Vice Chairman. Ms. Madden, maybe I missed it when you testified. Is your client still incarcerated?
He is. He's life sentence, Mr. Chairman.
Any other questions from the committee? Thank you, Ms. Madden. I'm not seeing anybody else online. Senator Landon, would you like to say anything else on the bill?
Well, Mr. Vice Chairman, I appreciate Emily coming on and giving you a little bit more background on what we're dealing with here. We're in a time constraint time in our session, and so I'm sorry that you couldn't hear from the University of Wyoming professor. We have quite an expert over at the University in Laramie. She came over and testified on the Senate side, and absolutely fascinating. Actually recommended that this date be moved forward as far as 2016. DNA evidence testing, as we all know, has come a long, long way. And so I would commend to you on the Judiciary Committee to keep that in mind. I think our DNA statutes may very well be behind in a couple of places. But I appreciate the opportunity to bring you this bill, Mr. Vice Chairman. I think it's a good little fix that obviously means a lot to one particular individual. So,
Thank you, Senator. With that, we'll go ahead and see, are there any agencies that would like to comment? Any public testimony in the room? Senate File 101? Anyone else online? All right, with that, we'll close public testimony. Committee, what's your pleasure? Moved by Representative Chestick, seconded by Representative Filer. Any discussion on the bill? Representative Kelly, we have an amendment.
Thank you, Mr. Vice Chair. Per Representative Webb, if we go to page 2, line 8, after the word convicted, insert the words on or.
That's on line 8, Representative Kelly. Okay, we have a second from Representative Webb. Is there any discussion on the amendment? Hearing none, we'll take a voice vote. All those in favor of the amendment say aye. Aye. All those opposed, no. The amendment passes. We're back on the bill. Any other discussion on the bill? Question being called. We're taking a roll call vote on Senate File 101. Pierre, thank you.
Representative Brady,
Aye.
Representative Breton,
Aye.
Representative Chestick,
Aye.
Representative Filer,
Aye.
Representative Kelly,
Aye.
Representative Lean, sorry,
Aye.
Vice Chair Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
9 ayes do pass amended.
Excellent. I'm seeing a lot of excellent names on this bill. Senator, who would you like to take it on the floor?
Vice Chairman, I was going to tip my hat to co-sponsors, pretty outstanding. I guess I've got all the information that I can sort of whoever would like to take that on the floor. It's happy to.
Majority of the committee.
Thank you.
Excellent. We'll have that on Representative Bratton. Would you like to take the lead on that? Thank you. The next bill, thank you. The next bill for our consideration is Senate File 71. Senator Brennan, welcome.
Thank you, Mr. Vice Chairman, members of the committee. Senator Brennan, I'm here with Senate File 71, Ignition Interlocked-In Restricted License Aggravated Homicide. I'm going to talk a little bit about how this bill came to us before, and then I'll go through the bill and what it does exactly. In the interim on Transportation Committee, we were looking at help the Department of Transportation came to us with a bill, a cleanup bill for their ignition interlock-in that has made its way through the legislature. And in that bill was this piece. The majority of the Transportation Committee over the interim felt like this was maybe a little bit more than cleanup. I felt like this was important, one, because I do feel like it was something that was missed with the original statutes that were put into place. But also, if it wasn't missed, I feel like this is really important for just criminal justice reform. So to begin with, this does have to do with aggravated homicide by vehicle with somebody who has a DUI. That is a serious crime. That we're not, not going to argue with that at all. But what this bill does is really, in the title of the bill on page 1, it's authorizing persons convicted of aggravated homicide by vehicle to be issued an ignition interlock-in restricted license. If you go over to page 2 of the bill, this is really where the bill is, and it's one of those where we reference a whole bunch of statutes. And so let me just tell you what this referencing of all these statutes actually do with the bill. So a little bit more, and I do have some handouts for you guys that kind of explain things from the Department of Transportation. But what this bill would do, it was allow for the issuance of the required ignition interlock-in after being convicted of homicide by vehicle while operating and driving a vehicle in a violation of Wyoming Statute 31.5 to 33 after the period of revocation, which is required by statute for 1 year. And let me pause here just a minute. What we're talking about here is somebody getting their driver's license back. This is separate from any criminal charges that is going to be handed down by a judge. Okay, so this does not affect like the conviction that a person would have. This is just talking about the ability to get a license back. Why this is important, because the way that the language is written currently with these aggravated homicides is that if you are convicted of aggravated homicide and you have a blood alcohol content of 0.14, you can get that driver's license back. Because of the way it's written, you can get it back with that ignition interlock-in after the period of revocation. If you blow 0.15, you can never get a driver's license back because of the way that that's written. And that's a pretty hard line and a pretty big cliff. From at 0.4, you can get your driver's license back. At 0.5, you can never get your driver's license back. So what this bill does is says you can get your driver's license back after that period of revocation with that ignition interlock-in. And hopefully if I explain this well, the Department of Transportation is here to clear up anything or answer questions. They're the ones that are like the gurus on this, but I'll take any questions.
Thank you, Senator Brennan. Any questions from the committee? Chairman Washit.
Thank you, Mr. Vice Chairman. So the goal here is to help the individual who's convicted of aggravated vehicular homicide get a driver's license back, or to force them to complete a year of revocation before they can get interlock technology in their vehicle?
Senator Brennan.
Yes, and maybe the department can help me like explain like that whole process. But right now they can't get that because they can't get that during the period of revocation is my understanding. But they're the experts on this.
Excellent, thank you. Please state your name for the record. Welcome.
My name is Renee Cosina. I'm the Deputy Program Manager at YDOT Driver Services. So would you mind, Chairman Washit? Okay, I'm sorry. I'm first time, so thank you for your patience with me. Vice Chair Singh, can we have that question repeated?
Sure, Mr. Chairman.
Thank you, Vice Chair. So I guess what I'm looking at is the goal of the bill here. Are we trying to help these individuals get their driver's license back and get interlock technology provided? Or is the primary goal here to preempt them from getting technology until after they've served a year of revocation? I guess that wasn't completely clear.
Ms. Casina.
Vice Chair, Chairman Washit, The intent of the change is to have the person who was convicted under driving by the statute 62-106, homicide by vehicle, they would serve their revocation time. And after that time has been served, they would be eligible to get an ignition interlock restricted license. The way it reads right at the moment, if they are convicted and their blood alcohol content is 0.15 or greater, they would not be eligible for an ignition interlock restricted license at all, the way it currently reads. And the interlock laws say you cannot sit out that requirement. So they are stuck with not being able to get licensed at all after their revocation is served. So this change would allow them to do that. So they would serve their hard time revocation and then get issued their ignition interlock restricted license based on the time required by law.
Chairman Washington.
Thank you, Vice Chair. So I don't see any language in here about 0.15. So how are we addressing the 0.15 hard line that says no interlock device if you get you're revoked forever or ineligible for an interlock license if you're at 0.15 or higher? So I don't see anything about 0.15 in the bill.
Ms. Casina?
Okay, Vice Chair, Chairman Washit. So the statute under 315233F describes what the interlock time is for a person convicted for an offense that includes alcohol. If it's a first offense, your BAC must be 0.15 or greater to implement the ignition interlock requirement. If it's a second or subsequent offense, the blood alcohol content does not come into play. The time prescribed to get the interlock is all outlined in there. So where we're mentioning the 0.15 is if you're under 0.15 and it's your first offense, you would not have to have an ignition interlock requirement. So the way the law is currently read, when you're done with your revocation, you'd be eligible to apply for a non-restricted license. If you were 0.15 or this was a second or subsequent offense, you would have an interlock requirement, and based on the way the law currently reads, our department would not be able to issue you a license at all because it states you cannot get an interlock license, and you must have one for the period of time prescribed by law.
Thank you, Ms. Casina. Any questions from the committee? Representative Filer?
Thanks, Mr. Vice Chair. My question's actually on page 2, starting on line 8. And I'm no attorney, so I don't know how to read all this or if this has anything to do with post-convictions, but it says this act shall apply to persons convicted of aggravated homicide by a vehicle or for causing death to another person while operating or driving vehicle in this violation of this statute before, on, and after. So does that capture everybody that's had this affected them in life is pretty much what I'm reading it as? So anybody before?
Ms. Casina? Senator Brennan?
Mr. Vice Chairman, Representative Filer, yes, the reason that this is written like that is so that if somebody then were to be allowed to have this after their period of revocation, that they can go back, and so that we're not causing somebody who was caught in this law to not be able to then get that driver's license back. Does that make sense?
Mr. Vice Chair, yes, it does. And I just want, if I could follow up, is will there be a notification process?
Senator Brennan?
That's a great question. I don't have an answer to that, but I can get you an answer. I would guess that there is a way that is, but I don't know how that process works. Maybe the department.
Ms. Casina?
Vice Chair, Representative Filer, are you saying an overall notification when the law goes into effect, or notification to only the drivers affected by this?
Mr. Vice Chair, the notification process, I'm just thinking there might be a lot of folks out there that will never even know this law goes into effect. But they're on the books, they've been convicted years ago. would there be a notification process through the Department of Transportation to at least notify those folks that they actually could reapply and maybe go through this process to get their driver's license back?
Ms. Casino.
Vice Chair, Representative Filer, currently, when a person has gotten to 3 months before the end of their revocation, our department does have a process to notify them of what the next requirement is to get their driver license back. So anyone who is currently serving a revocation, they would be notified. And all previous people, or all previous drivers have been notified in the past with that same process. So when they contact us to try to get their license back, we would walk them through that process.
Representative Lean? Okay. Any other questions from the committee? Representative Bratton.
Thank you, Mr. Vice Chair. So I just want to make sure that I'm understanding this correctly. Currently, after their conviction and they go through the revocation process, they may get their license back with no interlock after a year. And this would tighten it up so that they would have to get an interlock. Is that correct?
Senator Brennan.
Thank you, Mr. Vice Chair. Representative Bratton, no, that is not correct. Currently, as the law is written, there isn't that period of revocation that they can then go get their license back if they have a .15. So they can never, ever get their license back and drive in the state of Wyoming or any other state. So what this bill allows is for that period of revocation, then they can go get that driver's license with the ignition interlock in so that they can get a driver's license back.
Thank you.
Any follow-up? Representative Kelly.
Thank you, Mr. Vice Chair. I'd just like to ask if this illustration I'm going to give you is correct, so we understand this bill correctly. Somebody drives very drunk, kills somebody, is convicted of aggravated homicide, serves out the sentence, becomes sober, has been sober for 10 years, under current law cannot drive to work because there's no way to get the license back.
Senator Brennan.
Representative, Vice Chair Singh, Representative Kelly, yes, that is correct.
Representative Brady.
Thank you, Co-Chair or Vice Chair. Here's my question. This is going to take away any, it was cut off at .15 for BAC, but so it's going to take away, there's not going to be any level, BAC level that would, I mean, it's going to take away the entire BAC charge.
Senator Brennan.
Thank you, Vice Chair. Representative Brady, I think what's important here to note is that this just deals with the ability of an ignition interlock-in for somebody to get their driver's license back. Currently, the way the statutes are written, if you have a .14 and you commit this crime, you can get your driver's license back. If you have a .15, you can't get your driver's license back. This is only talking about the ability to get your driver's license back. This doesn't go into our criminal statutes and deal with, this person is still going to have to go through the court system. The judge is going to still give them their sentencing. This just deals with the driver's license. This doesn't deal with the sentencing. So the judge can still go in and do what he says to do. And I think where it's, Chairman Washit alluded to why some of this too is confusing in this bill, because we reference a lot of statutes. And he said, I don't see this .15 in here, it's not in there. But it's because we add, on page 2, lines 4, we put, unless the person has first completed the period of revocation provided under Wyoming Statute 31-7-127B for each conviction under this section. So that's where we go in, and that's where we add this place where if you do have that 0.15, you can get your driver's license back. So I would note that between that 0.14 and that 0.15, you're committing the same crime. We're just, for whatever, reason, and it was believed by the department, and I myself believe that it was missed in when these statutes were written, that there was this hard line between these two.
Any follow-up?
Not necessarily. Thank you for that clarification. I was just, I just want to make a statement. Yeah, I get that point. So, and the judge may make determinations of, sentencing or whatever, but I understand about the driver's license. We're taking care of that now regardless of any alcohol, blood alcohol content.
Thank you, Representative. Any further questions from the committee? Representative Chestick.
I think I understand, but let me just make sure I clearly understand what's going on here. Currently, if I blow 1.14 and I serve out my revocation time, when that's over with, I can go back and get an unrestricted driver's license back, no interlocking device. If I blow 0.15, I can never get that back. And with this bill, that changes that both of those conditions have to have the interlock. Is that what this bill does?
Ms. Casino.
Vice Chair, Representative Chestick. So I think in the past, before July 1 of 2019, you could essentially sit out any interlock requirement. So you could choose not to drive, and then you could get an unrestricted license back. And so under the statute as it's written now, a person could do their revocation time, which would probably overlap any interlock requirement time, and then get an unrestricted license at the end of that revocation. When they passed that you could no longer sit out a prescribed interlock time, which for a first DUI, it's 0.15 or greater is your BAC to have an interlock. Second or subsequent, there's an interlock requirement regardless of BAC. And so depending on what has been happening when you get convicted of this particular charge, then you would not be able to get a license if you had an interlock requirement at the end of that revocation, because you are not eligible for an interlock restricted license based on the current law. So if we add this verbiage in there, you serve your hard revocation time, and if you do have an interlock requirement, then you can get your ignition interlock restricted license and move on with life. If you don't have an interlock requirement because your BAC is under the 0.15 and it's your first DUI, or you were convicted of drugs only, then you would be able to get a non-restricted license at the end of the revocation.
Thank you, Ms. Casino. Chairman Watchett.
Thank you, Mr. Vice Chair. So, Ms. Kachina, I'm wondering if I could ask a favor. Maybe a flow chart with some of the if-thens. I'm picturing myself on the floor trying to explain this to the body and getting hopelessly lost. And so I'm asking for a favor. If we could get, I see a head bob in the back door, some type of flow chart that says, if this circumstance, then this, if this, then this, and which way the arrows flow. And then in addition to that, are there any complications with different classes of driver's license? If we're dealing with the CDL, does that change the picture here in terms of federal restrictions on commercial driver's licenses if we're now giving somebody an opportunity to get their license back? How does the CDL fit in?
Ms. Kachina.
Vice Chair, Chairman Watchett, if you have an ignition interlock requirement, you are not eligible for a commercial driver's license. If you have been convicted under any of the statutes that are driving while under the influence, whether it be vehicle aggravated homicide by vehicle, or under the DUI statutes, you will have a disqualification of your commercial driving privileges. And in addition, the ignition interlock statute specifically states you are not eligible for an ignition interlock restriction on a commercial driver's license.
Representative Lean.
Thank you, Mr. Vice Chair. Thank you for coming today. My question has to do with the intent of the bill as it was originally written. Because driving is a privilege and it's not a right, do you believe that maybe that hard line was drawn because this is involving a vehicular homicide?
Ms. Kachina, Senator Brennan.
Thank you, Mr. Vice Chair, Representative Lean. No, I believe, so if we go back, this was in, I believe it was 2019 that the ignition interlocking statutes were written. That's a relatively new tool that we have for these things. And the Department of Transportation and myself believe that it was an accidental miss in the way that those ignition interlock-in statutes were written, because this was not the way it was before those ignition interlock-in statutes. And so we're not arguing that this isn't a serious crime, but what we are saying, and what the department said during the interim, and what I believe too, is that we've got an inequality here. And so we're just asking that the penalties for this be equal, like across the board, for somebody who gets convicted of vehicular homicide by DUI.
Any follow-up? Representative Webb.
Thank you, Mr. Vice Chairman. My question or my suggestion would be with the flow chart, I think is a great idea. If I remember back from my days of my previous life, a judge has nothing to do with suspension of driver's licenses. And so there's two separate procedures that are gone through. One is the court, one is the driver's license. And I think just to make that clear on the floor, that would be good to, I can't remember what the term is that those proceedings are, but to show on that flow chart, there's the judicial proceeding and then the driver's services proceeding, whatever it's called.
When in doubt, consult the flow chart. That's all I sound. Yeah. Any other questions from the committee? Chairman Watchett.
Thank you, Mr. Chairman. So, Senator, I support this concept. It just seems that it's that differentiation between 0.14 and 0.15 being an absolute breakpoint just doesn't seem to make a lot of sense to me, and that's why I support the idea of this opportunity. At the same time, I guess on your end of the building, did you hear from victims of DUI, vehicular homicide cases, and those sorts of things? Did the victims come forward, and did they have any sense that this was being soft on crime, that we were giving people back their driver's licenses that maybe should never get a driver's license?
Senator Brennan.
Chairman Washut, thank you for that. What we did have over there was a member of our body that I talked to who has been affected. I'll share two stories that had been affected, losing a family member under this, and they were supportive of this bill. The second story that we heard from over there was from one of our senators. Senator Barlow has a great story where, if you guys will remember, back in 2001, I believe it was, we had 8 track members at the University of Wyoming that were killed by a drunk driver. Senator Barlow talked on the floor about how today he goes to church with the young man who was the drunk driver and one of the moms of those that was killed. And he talked about how they go around the state now together talking about drunk driving and effects of that. But over on our body, I think recognizing that this really goes to the place of punishment, that we have a judge that convicts people, that they serve out their time, but once time is served, we don't want to be punishment for life. We want these people to be able to come back in and be productive members of society. And part of that is being able to get a driver's license, to be able to drive, to be able to go to their kids' functions, get a job, provide for their family. We understand that this is a serious crime, but in society, let's let the judge do his job. Let's do our job in making sure that once time is served, we're not going to the spot of punishment.
Thank you, Senator Brennan. Any other questions from the committee? Nope. Thank you. Do we have any other comment from the department?
No, Vice Chair.
Thank you. All right. Well, seeing no other comment, let's go. We'll open that up to public comment. That's perfect.
Mr. Vice Chairman, members of the committee, my name is Tyler Lindholm. I'm the State Director for Americans for Prosperity here in the state of Wyoming. One of the aspects that I did want to mention was kind of alluded to, as far as recidivism is concerned with DUIs, the National Health and Traffic Safety Association, I think I'm saying that right, the NHTSTA, has looked at this pretty repeatedly as far as DUIs and how often it reoccurs. Fully about 1/3 of all DUIs end up as repeat offenders. The interesting part about that is it happens within the first 2 years after the initial offense. When we're looking at restorative justice and we're looking at justice reform and those types of things, that has to be part of that calculation when you're looking at these types of legislation. Now, obviously, that doesn't take into consideration somebody that has committed a vehicular homicide. Or as it's cited in the legislation, there's going to be a huge period of time before somebody even is looking outside of a window before they can even consider going to another vehicle. So part of that process, I think, is important to take into consideration. That 2-year time period is most likely for someone like this going to be 10 to 15. Before they even look outside at a vehicle again. So with that, Mr. Chairman and members of the committee, Americans for Prosperity, my organization, and our activists support criminal justice reform and restorative justice. And when we're looking at something like this, it is important that the state of Wyoming, and particularly the Judiciary Committee, do weigh out the seriousness of this crime, but also weigh out the situation that it is imperative that we do look towards, at some point, welcoming that individual back into society. And we think this balances that metric as far as they have to complete all of these steps before they can even look at another vehicle, to including that ignition interlock. Including that ignition interlock is such an important part of this. So with that, Mr. Chairman and members of the committee, I'll stand for any questions.
Thank you, Mr. Lindholm. Any questions from the committee? Chairman Washit.
Thank you, Mr. Chairman. Do you see this as being particularly important in a state like Wyoming with the distances that we have, that someone without a driver's license is at a significant disadvantage when it comes to being able to hold down employment and live a law-abiding life?
Mr. Lindholm.
Yeah, super good question, Mr. Vice Chairman, and to the chairman's question. I think it's a super imperative. Mr. Chairman, just a couple of years ago, this committee specifically focused on the Restorative Justice Act and being able to put something like that in place. Shortly thereafter, an individual from my little hometown ended up hearing through some mutual friends that I was geeky about this topic. And so he came down to talk to me, and this individual had been packing a felony for most of his life, since the time he was 19 years of age, and this individual is right around 55, 60 years old at this time, and could not enjoy any of the things that he lost when he was 18, 19 years old. The right to vote, the right to carry firearms, all of those things. And so we were able to look at his offenses and found out that he did qualify for the Restorative Justice Act in the state of Wyoming. And about a month later, he came to my office with a certificate, and he was so happy. He was crying. He was a 55-year-old man, and all of a sudden, he had all of his rights back. And so when I think about this legislation and eventually an individual going through all of the hoops to pay for his crimes and pay his debt to society, and at the very end of the rainbow, never being able to drive his kids to town, his or her kids to town, never being able to go pick up groceries, never being able to do any of those things, this is the right step that kind of fits that niche as far as ensuring that offenders, pay their debt to society, but also at the same time knowing that by doing so, there is light at the end of the tunnel. Mr. Chairman, to your question, absolutely. I think this is so imperative in a state like Wyoming where it takes, I live 30 miles from the closest grocery store. I don't have any DUIs, but I think it's an important part. Most people don't live very close to town.
Thank you, Mr. Lindholm. Mr. Chairman, any questions? Any other questions from the committee? Seeing none, thank you.
Thank you.
Pierre, do we have anyone online? All right. There's no public comment. We'll go ahead and close public comment. Committee, what's your pleasure? Move the bill by Filer, seconded by Representative Webb. All right, is there any discussion on the bill? Any amendments? On discussion, Representative Bratton.
Thank you, Mr. Vice Chair. Our state has one of the highest, the nation's highest rates of alcohol-related deaths, and I'm just not 100% on the nuances of this bill and its implications. This deals with a crime where somebody lost their life, and that's pretty much as serious as it gets. And I understand that redemption is a great thing, and we want that to happen, but I'm just not comfortable voting on to pass a bill with these kind of ramifications without fully understanding the effects of the bill.
Thank you, Representative. Any other discussion? Representative Filer?
Thanks, Mr. Vice Chairman. I think this bill's good in many ways. We hear the stories of a lot of these young folks, 18, 19 years old. Now they're going to have to go through the rest of their lives, living with the crime that they committed. And that's hard enough as it is. But as we look through to their later on in life, as far as workforce, things like that, we are a very rural state. And you know how hard it is for somebody to get a job, maybe in an oil rig somewhere or something, and say, hey, can I get a ride? Can I get a ride? Can I get a ride? I mean, so when we look at that part of it, restoring those rides after they've done all the time in jail and prison, they've had all the time to think about this. They've had all the time to speak with the victims' families. All these things come into play, and to be able to cut it off at a 0.0 or 0.14 to a 0.15 is a pretty definitive line, and there's no difference between the two. Really, there isn't. So I think looking at this Senate file to move forward is a good thing, because I think it's a good discussion that we need to have. With that, Representative Bratton brought up, our high rate of offenses with alcohol and driving. Well, those statistics are correct, but we got to remember that's a population, goes by population too. So like one of these crimes is like 15 or 20 of these crimes in California. When we look at population to actual crimes being committed and how many. But I think this is a good step forward. I really do. There's a gentleman in my district that this would absolutely make his life better. Be able to take his mom, because he takes care of his mom and she's elderly, be able to take her to those appointments and things like that. So I think and he's had to live with his mom most of his life now because of certain things like this and the crime that he did commit, which is the same homicide with a vehicle aggravated, and he had a DUI. So this, he is now in his 50s, his mom's in her late 70s, but he has to call Ubers, things like that all the time just to even get his mom to the doctor. I think this would change the whole realm of things. Maybe he'll be able to take his mom to Yellowstone, whatever it might be. So I'm on support of this to move it forward, Mr. Vice Chair.
Thank you, Representative. Representative Lean, did you have a? Representative Webb.
I too am supportive of this. In my previous life, I remember one individual that I arrested for a DUI that had killed an individual, and I've run across that individual many times over the last few years. I've never discussed it with him. I don't even know that he knows that I am the officer that arrested him. But I even knocked on his door as I was campaigning this last time. Seems to be a productive member of society, and so I would be supportive of something like this.
Thank you, Representative. Representative Lean.
Thank you, Mr. Vice Chair. Can I bring the bringer of the bill back up and ask a question? Is that a permission?
Sure. The Senator. Welcome back.
Thank you, Senator. Thank you, Mr. Vice Chair. My question is, what about multiple DUIs? I've been scouring the statutes while I've been sitting here that are referenced, and I can't find anywhere that it references multiple DUIs. Do you know, will this also apply to those that have 3 or 4 DUIs?
Senator Brennan.
Thank you, Vice Chairman Singh. Representative Ling, this is dealing with a first offense.
Any other questions or comment from the committee? Representative Brady.
Thank you, Mr. Vice Chair. Just as I was going to say, it only applies to the first offense. And so if, I really see that as a motivation for sobriety so they can get their license back for their life. Thank you.
Any other questions, comments from the committee? Mr. Vice Chairman.
Thank you, Mr. Vice Chairman. So on the flow chart, simple is better. Keep it specific to the issues in this bill. Thank you.
Thank you, Mr. Chairman. Representative Kelly.
Thank you, Mr. Vice Chair. As far as the 1.4 versus 1.5 goes, it's really not something we need to be concerned about. When we talk about the signs of alcohol tolerance, somebody can have a higher number and act more sober than somebody who's a newbie to drinking anyway. So we shouldn't concern ourselves with that. We're talking about the difference here. We had a bill earlier about predators, people who are actual dangers to society, whether they're on a substance or not, versus somebody who might have struggled with addiction and have beaten it, or just made a horrible mistake in their youth. Or also, I don't think it was mentioned that without this change in statute, there's an incentive for someone to drive without a license, without an interlock at some point, especially if they live in some rural area where the roads aren't heavily patrolled by law enforcement. This just seems like common sense. I'm in favor of this.
Any other comments from the committee? All right, thank you, Senator Brennan. Well, with that, if there's no other discussion on the bill, we'll go ahead and close discussion and take a vote. Pierre?
Representative Brady?
Aye.
Representative Bratton?
No.
Representative Chestek?
Aye.
Representative Filer?
Aye.
Representative Kelly?
Aye.
Representative Lean?
No.
Vice Chair Singh?
Aye.
Representative Webb?
Aye.
Chairman Washut?
Aye.
7 ayes, 2 noes, do pass.
Thank you, everyone.
Mr. Vice Chair.
Mr. Chairman.
The sponsor of the bill asked me if I would carry the bill on the floor, and I'd happily do so.
Once you get the flow chart.
Once we get the flow
With the
chart.
flow chart, yeah.
Thank you, Mr. Chairman. We'll do that. And I am a co-sponsor on this bill as well, so I will be backing you up.
Thank you.
All right. The next bill for our consideration is Senate File 116. Senator Nethercott, welcome.
Good morning, House Judiciary. It's good to be with you here this morning. Good representatives, this bill, anti-money laundering, is a bill brought to you as a result of the interim committee of the Joint Appropriations Committee that took up the topic for gaming in our state. And as part of that process, the state and the Gaming Commission and the governor's office are concerned about whether or not our gaming laws are where they need to be. They're new, and obviously we've all seen that growth of that industry, particularly here in Laramie County and otherwise. And so consultants were brought in from other states who work in the gaming industry and reviewed our statutes. And one of those recommendations from that consultant group, as they identified, was the need for an anti-money laundering statute. And so that's why this bill is in front of you. Money laundering is a crime, should be, but we ironically or curiously don't have one here in Wyoming. So wanted to definitely close that gap as we continue to see the growth of the gaming industry. There's one particular industry is now about $1 billion annually in the state of Wyoming that's here doing business in the state. And so that amount of money really attracts a different level of potentially organized crime and different level of criminal activity that Wyoming may not quite be ready for. At least I don't think it is. And so want to make sure we have appropriate deterrence in place and laws in place in order to ensure that we don't become a place where that level of organized crime is attracted to the type of money being generated from our gaming industry. The bill is not limited to gaming, but it is as a result of that gaming interim topic, that identification by those consultants, and a recognition that the activities in our state are changing as a result of the gaming. So money laundering just plainly is when you take illegally obtained money and you take it to another location like a gaming, like a casino or a gaming facility, and you turn in that money in exchange for chips, or, in exchange for the ability to play, and then you cash out, and then the money's clean at that point. So you take, let's say, your $100,000 from a drug transaction, you take it into the casino, and they're used to dealing in billions of dollars, right? So that's kind of just to connect that back, high dollars. And so it wouldn't necessarily be completely atypical to see that amount of money be brought in. They then get chips, they play for 20 minutes, they cash out, they get their money back from those chips, and walk away with $100,000 clean cash. And it's a way that they can say of how they kind of laundered it. That's a very simplistic version of how this looks. Obviously, there's significantly more sophisticated and complex schemes that are conducted, but that's it, really simplistic example. The statute associated with money laundering seems kind of broad, and it is. So that's a concern if you read the language of the statute, but this is how money laundering statutes work across the country and at the federal level as well. So this particular bill draft originates from New Jersey, which is where the consultants were from. And I thought that's a pretty good starting place, since they know their way around organized crime and money laundering. And that particular law has been tested, obviously, a lot. And so adopted the language that they had from New Jersey and modified it to be consistent with Wyoming law. So as we go through the bill, it provides those definitions for how the money is obtained, that derived from, what property is, which is really anything of value. And so money laundering doesn't necessarily have to be money for money. It can be gift cards are used oftentimes as part of an illegal scheme. Any type of good that can be transferred for cash is certainly part of this crime. So here's the onus, which is reasonably should know to be derived from criminal activity. How would one know what that means? And that's a pretty common concept in our criminal code. And so Representative Webb may recall from his time as a law enforcement officer the crime associated with buying or receiving stolen property. What would clue you in that you are buying property that's been stolen, right? Is there facts in that circumstance that would justify that? So I want to sell to you a brand new iPhone for $200. Is that maybe too good to be true? I don't have a receipt for it, and I come up with some story that may clue in a reasonable person that that property may be stolen, depending on the circumstances, right? So that's a common fact that we see right now like buying and receiving stolen property, that kind of a concept in the law. So reasonably should know is a concept there. Now, moving on to page 2, the bottom there. Directs, organizes, finances, plans, manages, supervises, or controls the transportation or transportation that he should know to be derived from criminal activity. When you're talking about money of this type, it takes a lot of effort to make it clean, to launder it. And so there's a lot of different schemes typically associated with this type of industry, organized crime primarily, in order to launder the proceeds of the illegal activity. Kind of moving down, it requires the intent to facilitate or promote criminal activity. So this is one of those, I think, saving mechanisms within the law. You have to have the intent to facilitate the criminal activity to be guilty of this crime. So even if maybe you should have known you were buying and receiving stolen properties, if it can't be proven that that was your intent to facilitate that crime, then it doesn't apply. Moving down, knowing that the transaction, so here's this element that you actually have to know that it was intended to conceal the actual source of the funds. Here's the other options moving down on page 3. Similar there, and I'm happy to answer your questions to see any of your interests. Moving down to page 4, illegal investment penalties. It's not uncommon for these illegal proceeds to be invested in different type of investment schemes, and that's also illegal as well. The structuring of funds, so this could be also like Ponzi schemes or other types of efforts to, again, take illegally obtained money and try to sanitize it into something legitimate, right? So there's a lot of financial schemes out there that would qualify for money laundering. That, good representatives, is generally the bill. I'm happy to answer questions to see where you may have concerns or to explain with more thought. One piece I will bring to your attention is page 4. There's a reference to federal law and that the Code of Federal Regulations. That's a reporting requirement that all of these institutions have for reporting reasonable suspicious activity. And this is a law that already applies to them, that they have to report. So casinos, which are not our gaming facilities here in the state, but it's important to recognize that they have requirements on federal law to report to the federal government, typically the FBI, to report suspicious activity. This also facilitates domestic terrorism, foreign terrorism, all kinds of cartel-related activity as well. It captures all of this. And so if the casino sees somebody coming in with $250,000 and cashes that out in 20 minutes, they have to report that as suspicious activity. So that's a reference to that federal code.
Thank you, Senator. Any questions from the committee? Representative Chestick.
Thank you, Mr. Vice Chairman, and Senator Cotton, thank you for bringing this bill to us. I have some concerns. You mentioned this is a broad bill, and that's my concern, is overbreadth, unintended consequences. And let me just see if I understand. It's really lines 15 to 17 on page 2 that bother me, but here's what bothers me about them. We're creating a new crime of money laundering, and there's really 3 different ways, mutually exclusive ways that you can commit the crime. And there are 3 different ways because of the word "or" at the very bottom of page 2. So you do ruminant I, or 2, or 3. So any one of those 3 things would be the complete crime, correct? So each one of those 3 things stands independent of the other. And ruminant 3 is the heart of the bill. That's what you're trying to get at, and I have no problem at all with that. I'm concerned about ruminant I. Transports or possesses property the person knows or reasonably should know to be derived from criminal activity. Is that overbroad? So the hypothetical that comes to my mind is somebody accepts drugs, which are derived from criminal activity because they're illegal. They accept drugs, they possess those drugs in exchange for sexual favors or whatever. Have they committed the crime of money laundering? If you look at, if ruminant I stands alone, all the elements of the crime are in that, they've transported possession of property which the person receiving the drugs knows are derived from criminal activity. They've committed a crime of money laundering, which I know is not the intent of the bill. But it looks like we have basically created a new crime for minor drug offenses that could be a 10-year felony. And I'm concerned about the overbreadth of that particular Romanet I.
Senator Nethercott.
Thank you, Mr. Vice Chairman. I think that's a reasonable concern, Representative, as you point that out. Just give me a minute to look at. I think that if there's some amending language that we can have there or potentially strike it. One concept that is in the law currently, right, is you mentioned drugs. So, it is illegal to transport money or drugs. So if someone says, hey, I have a job for you, you look very nice, I'll pay you $5,000 to drive across the country, don't look in the trunk. That happens all the time. Those are called drug mules, or other mules to facilitate criminal activity. Okay, sounds like a nice deal. The man was very nice. He offered me money. I need the money. All I have to do is not look in the trunk. I have a clean driving record. I'm usually a middle-aged female driving a Honda Civic, across the country. All works well. That's still illegal. Willful ignorance is not acceptable in the law, so reasonably should know is there. So that's just a concept I want to place potentially as maybe you hopefully amend this particular piece. And if you want to amend it to be felony level or in the facilitation of criminal activity, and that way it's not misdemeanor level drugs or misdemeanor level anything, and to limit it to that felony piece.
Any follow-up? Representative Kelly.
Thank you, Mr. Vice Chair. I focused in on the exact same place that Representative Lewis Chastek had. The part that says a person is guilty of money laundering if the person transports or possesses property, the person, we know what that says. But if we go over to page 4, the penalty for money laundering is a felony of up to 10 years or $10,000. So here's a hypothetical that I got tripped up on. Say somebody possesses property they should know is stolen because it's a $400 PlayStation that they bought for $50. According to this, they might be guilty of money laundering and a felony when under receiving stolen property statutes, it's a misdemeanor. So I'm wondering if there's a conflict there. Can you speak to that?
Senator Nethercott.
Mr. Vice Chairman, I don't know that there's a conflict. There is theoretically a conflict there. Generally, when somebody commits a crime, there are many potential crimes that person may have violated, such as possession of drugs versus with intent to deliver, depending on some of the facts, and the prosecutor or the law enforcement officer has discretion to decide. I think what's missing here that both the representatives have identified is a limitation on a threshold requirement, which may be the conflict, which is like property damage is $1,000. So if you steal property or you damage property that's over $1,000, that's a felony, I believe subject to a 10-year felony as well, or a 5-year felony, which is consistent in our criminal code. Every felony is generally 0 to 10. But potentially absent here, and I'd ask you to take a look at, is that threshold, which I would suggest for purposes of now, $1,000. So it is consistent across the board. We've looked at that historically, just for some background information of whether or not that 1,000 should be raised. The legislature generally has been unwilling to increase it. It's probably always prudent to continue to ask that question for whether or not that should be raised. But I think having a threshold in this bill would be prudent.
Thank you, Senator. Chairman Watchett.
Thank you, Mr. Vice Chair. I think we can work with the bringer to come up with language for a committee of the whole amendment to deal with this. I'm a little concerned about it just putting a dollar threshold, because you can have felony level crimes where, you know, a robbery that steals a $10 wallet is still a felony crime. And so some type of felony threshold language, I think we can massage that a little bit as a committee of the whole amendment.
Thank you, Mr. Chairman. Representative Bratton.
Thank you, Mr. Vice Chairman. So I notice on page 3, Roman numeral 3, it does talk about transaction. Like, that seems more in line with the definition of laundering to me, because there's an actual transaction, whereas back on page 2, Roman numeral 1, under B, it's just about possession. And then on Roman numeral 2, it also talks about transaction, but then there's also possession. So maybe if we could tighten it up to transaction, which is the money laundering, the actual verb laundering part of it, that might be helpful as far as an amendment goes. Do you think?
Senator?
Yeah, Mr. Vice Chairman, I don't think it would be ill-advised to strike that first Romanette, where it transports or possesses. I think particularly right now, from my viewpoint, just having an anti-money laundering statute on the books is a good idea, so we don't attract bad actors, and we can continue to look at it as we understand. So I think probably for now, we don't want to capture too much, and so I think even striking that is a good idea, and then further understanding how to provide parameters.
Any follow-up, Representative Bratton?
Sorry, yes, thank you. And then maybe in 2, let's see, strike 1, and in 2, delete the transportation of, but leave the transaction part.
Senator, that looks good. Okay. Representative Lean.
Thank you, Mr. Co-Chair. Thank you, Senator, for coming today. My question is about the fine of $10,000 that's mentioned on pages 4 and 5. My question has to do with those that are victims. If their money laundering property that is harmed is greater than $10,000, is there a way we can leave that open to a judge's discretion?
Senator?
Yes, Mr. Vice Chair. So restitution is always authorized in our criminal code, and restitution is based on the amount that's owed. That is not part of the penalty. And so a fine is really the punishment portion of it. It's actually rarely exercised in the courts, because typically there's restitution that's ordered, and you want the defendant to be able to pay that and maybe jail time or whatever. So fines are generally not the first choice the courts go to, but those are separate and apart from restitution. So whatever restitution there would be in the case, that would likely be ordered to whatever amount that was.
Any follow-up? Any other questions from the committee? All right. Thank you, Senator. Did you have any people that were going to comment on this bill? All right, I don't see any agencies. I don't see any public comment. All right, I will close public comment. Thank you, Senator. Committee, what's your pleasure? Move the bill by Filer, seconded by Bratton. Any amendments that we'd like to see on the bill? Representative Chestick.
I'm not going to propose an amendment right now, but I do think I would like to work with the bringer of the bill to work on Roman I on page 2, and we can talk about that offline, but I just wanted to let everybody know that I'm okay with passing the bill forward so we can continue to work on it, but I do have some things we need to work on at committee of the whole level.
All right, any other potential amendments? Seeing none, any discussion on the bill? Representative Filer.
Thanks, Mr. Vice Chair. I think in my community especially, there's been a lot of concern about places that are like casinos. They're popping up all over the place, and people are wondering what the regulations are on them, if there is gonna be any type of illegal transactions. So I think in our community here in Laramie County, this is big. This is something we can go back to our constituents and say, hey, we're really looking into this, making sure we're trying to keep the crime down, make sure there's no money laundering coming in, or doing the best that we can, but, and also giving law enforcement those tools. So I think this is a great bill to move forward, and working with the bringer on a couple of amendments, I think it's gonna be a good deal.
Thank you, Representative. Any other discussion on the bill? All right, let's go ahead and call the roll on Senate File 116.
Representative Brady,
Aye.
Representative Breton,
Aye.
Representative Chestek,
Aye.
Representative Feiler,
Aye?
Representative Kelly,
Aye.
Representative Lean,
Aye.
Vice Chair Singh,
Aye.
Representative Webb,
Aye.
Chairman Washed.
Aye.
9 ayes do pass.
Senator Nethercott, did you have a preference on who would carry it on the floor? A preference, all right. I see a nice name right here. This is sponsored. We'll have that conversation. Excellent, thank you. All right, folks, well, we really did a good job getting all those bills passed.
Congratulations, Rep. Singh.
Vice Chair did well.
Thank you. So we do have just one little bit of business to talk about. On Monday during lunchtime, we will be meeting as a joint committee, if that's correct, to discuss interim topics for the Judiciary Committee. So just want to put that on your radar. Again, that's Monday, noon upon adjournment. So,
Are we meeting on Friday?
no meeting Friday. Thought you could sleep in today. All right.
I had it at noon, but now it's on adjournment.
Noon upon adjournment.
Oh, noon.
Yep. All right. Well, with that, we are adjourned.